Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video is useful for the interpretation students. Please remember, day before yesterday, there was a typical, almost heated discussion between the judiciary and the additional Solicitor General, Mr. Rajan, regarding the interpretation. Previously, I have made a video regarding AG Perarivalan case. So this case you already know, it is AG Perarivalan versus State of Tamilnadu, wherein this Perarivalan was overstaying or staying in the jail for the last 36 years. So without remission he stayed for 36 years, of course with remission 32 years, even it's a large period. He wanted remission, so this is the condition. He put a petition to the state is ready, even the Supreme Court is also ready to release him. But the point is, when the state government wanted remission, they have actually forwarded or they have written to the governor to pardon him. So Article 161 says, yes, the governor has got powers to cause Article, yes, I think, yeah, 161. The governor has got powers to pardon or to give remission or to give recipe, so many things he can do. Same thing applies to the President of India as per Article 72 or 71, like that. But here, what the governor has done, the governor has forwarded the recommendation of the state for the remission to the President of India to take further action. At the time itself, we commented, he passed the buck to the President. Actually, he has to execute his power. So please remember here, Council of Ministers, the governor has to get the aid and assistance of the Council of Ministers as per Article 163 of the Constitution of India. Before that, let us know Article 161, Article 162 also. Article 161 of the Constitution of India says, yes, it says the power of the governor to tender pardon. Article 162. So, governor is to act on behalf of the state or extent of the executive powers, we can say. The heading or subheading of the Constitution says 162. Extent of the executive powers of the state. That means governor is supposed to act on the recommendation of the state. So 163, Council of Ministers. So normally whenever any recommendation is sent from the cabinet to the governor, of course he has got a power of veto. He may reject it also. He may reject and send back for reconsideration to the cabinet. But if once again, if they conform to the former version, he has to pass the order. That's all. Okay, right? Anyway, the matter has been sent to the President of India. When was this sent? In the year 2021. Now we are in 2022. So still the President of India did not take any action. So when yesterday, so the two judges bench of Honorable Justice Lav Nageshwara Garu and B.R. Gavai, Lav Nageshwara and B.R. Gavai, yes, they said they would not adjourn the matter till the decision of the President is coming out. And now the point has come. Actually, whose duty or whose function it is to interpret the statute. However, we know Article 120, whatever it is, Article 120 of the Constitution of India, Supreme Court is a court of record. Definitely, it is the duty or it is the function of the court to interpret the law. What Additional Advocate General Natarajan said, the file is with the President of India, he will take action, he will, when the court asked this question, first of all, let us know this question. When the court asked her, why should governor send it to the President of India? Then he said, President of India will decide. That means you mean to say that President of India will interfere, will interpret whether governor has to send to the President of India or not, like that court questioned. For this, the Additional Advocate, Solicitor General, he has replied that the matter has come very recently, Your Honor. The President has to decide. What is Gava immediately retorted? What is immediately? So the matter has been, actually it has been pending for the last, from 2018 has been pending. In 2021, governor sent it. Now you say that very recently you have received it. So did it take 1 year for you at least to go through the contents, or you say that you want to escape that it has been reached very recently? It's not correct. Either the president has to decide, or as per the opinion of the Supreme Court, the governor has to decide, and immediately they have to. If not, please remember, the Supreme Court cautioned. Supreme Court is ready to release him as per Article 14 of the Constitution of India. Equality. Then we will not adjourn till the awaiting president's decision. We need not wait for the president's decision. So whatever president takes, whatever decision he takes, is not binding on us. So ultimately what I want to tell is the court clearly told that it is the function of the court to interpret, not any others. Simple. No doubt. President is the head of the constitution, definitely, as per the federal structure, he is the boss, he is the first citizen, but court need not care him also. And actually the court asked why the additional advocate general is interested in the liberty, in the interfere. Why should you interfere, he asked. Because he is representing the state, he is representing the center, therefore he has to interfere. But anyway, since the court is of opinion that governor has to decide, then on behalf of governor, some solicitor general or advocate general has to come. That is the intention of the court, right? So the government, this president of governor sent the file on 27/1/2021. It was today is, that is yesterday, 5/5/2002. How can you say that it is very recently received? And the main point, the question raised by the court is, how can Article 72 and 167, that is Article 72 power of the president, Article 161 power of the governor, how can they be merged? Everybody has got to do his own duty. So this is what is explained, or what is actually opined by the Honorable Supreme Court of India. Anyway, Supreme Court is ready to release him. Only governor has becoming an obstruction. Anyway, governor also has referred the matter to the President of India. If the President of India is kind enough to dispose the file within a week or so, matters will be finished. Otherwise, this will continue for some more time also. Let us see what will happen, right? So here, in this case, the two important points are whether Article 72 and Article 161 can be merged or not. Whether the President of India can interpret the sending of the recommendation of the governor to the President is correct or not. If those 2 points are clear, the case is very clear. Anyway, I am sure that he will be released on bail. Thank you very much.